431.
Okay.
With the dismissal of the remaining case.
Tell me which one we're dismissing. That'll be the easier one.
Okay. We're dismissing 353.
353. Got it. Thank you. Good morning, sir. Are you John Jones?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading in each case of the indictment?
Yes, Your Honor.
And obviously, Mr. Coleman, you've taken everything into consideration with regard to the facts, the jail incidents, as well as the wishes of the family in making these offers.
That is correct, Judge. And just for the court's information, there is a member or members of the victim's family here in the present room today.
Okay.
And I've conferred with her about the case.
Okay. Mr. Jones, this is difficult for me because based on your behavior, honestly, I don't want to give you I don't want to go along with anything. But it sounds like if Mr. Coleman has discussed this with everyone and understands the underlying facts of the offenses, what has been going on in a jail, I'm going to go along really only because I trust him to the extent that I do. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0523, you're charged with a first-degree felony offense of murder, and that's from April 28th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with, see, are we going on just, what counts are we going on that one?
Which case?
That's the unauthorized use of a vehicle.
Well, it's just the first paragraph.
First paragraph should be fine.
So the state jail.
Yes, ma'am. Well, I'm showing only one paragraph.
So it is that. Okay, gotcha. So you're charged in 24 DCCR 2431 with the state jail felony offense of unauthorized use of a vehicle. And that's from October 15th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with. And then finally, in cause number 25 DCCR 1352, you're charged with the first degree felony offense of aggravated robbery from September 18th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with. I have here on the tablet in all three of those cases documents that have your signature on them that the state's marked as exhibit number 1 before.
The judge opens with a striking admission. Based on Mr. Jones's behavior, she was reluctant to approve any plea deal at all. That tells you his conduct in jail had already become part of the sentencing picture. In criminal court, your actions after arrest can influence how much trust the judge places in your future. First impressions matter, but so do everything that comes after.
Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0523, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24 DCCR 2431, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25, DCCR 1352, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. These 3 cases will run concurrently, which means together at the same time. I'm going to hand you in all 3 of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Wilkerson. Now, let me tell you one more thing, Mr. Jones. You're still going to be in our jail for a limited time before they transfer you to TDC. You will pick up another charge as quickly as you do anything else stupid in our jail or here. And if you think it's funny to ask my bailiff what he would do if you tried to get his gun, you're going to end up with another charge. I know about every single thing you're doing. Don't think there's anything that you're doing out there or here that I don't know about. He could press charges on you right now. But honestly, we're ready.
Here comes the legal reality check. Mr. Jones pleads guilty to murder, aggravated robbery, and unauthorized use of a vehicle. The result? 2 35-year sentences plus an additional 2-year sentence. Even though they run concurrently, meaning at the same time, this is still a life-defining moment. One hearing, a few words of guilty, and decades are spoken into existence.
To get you out of our jail because you've been such a menace to everyone out there with what you're doing. And let me tell you, when you get to TDC, you think you're funny, you're young, you're not going to get away with what you're getting away with here in TDC. There's some bigger, badder, worse people than you there. And also, if you think you're going to make parole by acting how you've been acting, you're not. I would bet money today that you're going to be in our prisons for 35 years because you don't know how to behave. Prove me wrong, and that would be great. If you figure it out and start learning how to mature and act like a normal human being like the rest of us, but my money is on you not doing that. So I wish you'd prove me wrong, because everybody that has to deal with you, they're just doing their job, and you're putting them through all that. Is there a victim impact statement?
No, Judge.
Go back with the bailiff.
Thank you.
Thank you.
Thank you.
Thank you. Have testimony with regard to counts 1, 2, and 3.
Yes, the court would like.
Yep, I think I would.
Be on that call, Ms. Shakita Cole.
Yes, ma'am. Good morning, Ms. Cole. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be record will so reflect?
And Ms. Cole, as with every probationer, when they are placed on the court's probation, are they given the rules and restrictions placed upon them and what they are supposed to do to follow the court orders?
Yes.
And each one of those in detail is gone over with them so that they understand everything that they're required to do.
Yes.
Was Ms. Atkins so advised?
Yes.
At her intake?
She was advised at her intake and at a TTM at the Milton Center in person.
Okay, and describe for the court what a TTM is.
A treatment team.
Okay, so in your opinion, Ms. Cole, as her probation officer, was Ms. Atkins fully apprised and aware of what she was required to do on probation?
Yes.
And were in fact the majority of those things intended to help her?
Yes.
Was she advised that she was to report to the Community Supervision Department when directed by yourself and the court?
Yes.
And did Ms. Atkins, based on your review of the file, fail to do that on multiple dates, including but most likely not limited to November 4th of 2024, November 19th of 24, and, and was that in violation of her probation order? Or did she either complete the hours or immediately report to you, Starr, I'm reading that. No wonder everyone's looking at me.
I was about to say- I know, I was about to,
Community service. Well, that is in fact a condition of probation, right? Is it also a condition of probation that she is to report to you as to her address and so that you know where she is at all times?
Yes,
And if she does not do that, is it impossible for you to locate her?
that is correct.
Did she in fact immediately report to you her current address?
No, she did not.
Anything else? I know you and I have had a lengthy discussion about her that you feel would be appropriate for the court to know in conjunction with your testimony and your updated PSI.
The main thing is her mental health. She refuses to address that. We've made appointments for her with Spindletop and she didn't attend the appointments. She's 100% when she was out unmedicated. So that kind of interfered with her completing her services. And she maintained contact with the victim.
And now the judge drops the courtroom equivalent of a final warning label. She makes it crystal clear that sentencing is done, but consequences are not. Any further misconduct in jail, especially asking a bailiff about taking his gun, could trigger entirely new felony charges. Translation: the clock is running, and every bad decision adds more time.
So
Ms. Cole?
Just briefly, during your supervision of Ms. Atkins, were you able to supervise her at points when she was on her medication and not on her medication?
the entire time she has not been on her medication.
So she's been unmedicated this entire time?
Yes, sir.
Your supervision? Okay.
Anything else?
Nothing else.
All right, thank you, Ms. Cole. Any other witnesses with regard to the allegations? Based on the testimony,
Unless I may ask, Ms. Cole, Judge,
Yeah.
and you stated that earlier, Ms. Evelyn Thibodeau, I believe that is her grandmother, correct?
Yes, correctly.
hold on, ma'am.
At some point in time in November of 2024, was Ms. Atkins violating the condition the court had imposed that she not to have contact with Ms. Thibodeau for Ms. Thibodeau's safety?
Yes.
Thank you, Judge.
Any questions about that? About the count, that's count 8 with the contact? Okay. Then, at this time, based on the testimony, I am going to find count 1, 2, 3. Do you have anything to add that's not already in your report?
No.
So the main thing I want to make sure, Ms. Cole, I have a notation here to ask is, you guys were aware of mental health issues and had opportunities for Ms. Atkins to participate in mental health services, is that correct?
I made the appointments myself for her.
Okay. All right, argument, Mr. Lewis?
Well, Judge, I think definitely from the updated PSI we have, as well as I think there was some issues from the jail. If you look at those issues and activity, I think that goes directly to her mental health state. Unfortunately, she has not been on a mental health caseload. I think that definitely would benefit her, as well as, being able to take advantage of any services that Spindletop inmate tomorrow may have, or any programs that probation deems appropriate for her. I have had conversations with her and meaningful conversations with her where she has addressed to me her desire to take advantage of those activities if those available to me. She did understand that she had the safety opportunity that didn't go well, but I don't think the mental health issues were addressed, mainly just substance abuse at that point. I think if we can get a handle on that or get some work done with her to address the mental health issues, I think she would do a lot better in this situation.
And mental health help. So, Ms. Atkins, the problem is you're being given all the opportunities.
Yeah, but like I said, I don't know if I told you, I had an appointment in.
This is one of the most brutally honest moments in the hearing. The judge is not just talking about prison, she's predicting the future. Her message is simple: behavior determines outcomes. Parole boards look closely at discipline and attitude, and if Mr. Jones keeps acting the same way, those 35 years may become the full 35 years. Do you think he'll prove her wrong?
Court author because I cannot get into Bowman. They're not taking new patients.
So you had an appointment that Ms. Cole set for you, at least one, how many?
Yeah, but it's not for medicine. It's for psycho. I'm not a psycho. I don't have those problems. I mean, some people do that, I don't know.
Well, you obviously we don't know what you need because you won't even go do the evaluation. That it sounds like you haven't been on medication that would be, what?
Evaluation where?
At Spinal Top.
That's what I'm telling you, that's not, I don't have that, I'm not a psychopath. That is for.
It's psychopath, nobody's saying you're a psychopath, but you have.
It's called a PASS program, I'm not a psychopath, that's what I'm saying.
That's not what it's called, and that's not the reason it's called that, okay? If you had gone to your appointment and talked to them, then you would know what that was for, and you would know that it was meant to help you so that you could get on medication, stabilize, and not have the issues that you've been having. I'm going to find that you previously entered I'm sorry, Ms. Malfino, did you have anything to add?
No, Judge, I think that from my conversation with Ms. Cole, she's been gracious enough to offer to continue to work with her because I think she clearly sees the mental health issues. But as you can see, what Ms. Cole has been having to deal with is how the court has had to deal with Ms. Atkins today, and it's been kind of just
nature of the proceedings, and is then just really making a choice not to follow through with what programs have been given to you, Ms. Atkins, to try to help you. So at this time, any recommendation as far as?
I have one more thing to say.
Okay.
She is not giving me the information needed to follow up with those type of things.
Okay, well, I don't believe you. I don't believe you. Ms. Cole would never say.
The tone shifts from punishment to frustration. This part of the hearing shows a common truth in probation cases. Courts often provide treatment opportunities before resorting to prison. Mental health services, evaluations, and supervision are designed to help defendants stabilize. But those options only work if the person participates. When help is offered repeatedly and rejected, judges eventually run out of alternatives.
Go do something and not tell you where to go or help you get there.
No, she says she does not have a list of the community service.
I'm not worried about your community service. I'm worried about your mental health and the fact that you're not doing what you need to, and you're still contacting the victim, and it's a serious case. And so I got to protect society, unfortunately, because you're not choosing to. About to sentence you to prison, and how you keep talking over me is about to start adding years onto that. Stop talking. It's just going to get worse. Do you understand? Okay, I'm going to find sufficient evidence to find you guilty, and at this time, I'm finding you guilty of injury to an elderly individual. Sentence you to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit. You will receive credit on that sentence for any time that you've been in custody.
I have a doctor's appointment and everything. That's what I'm
I've got 5 more years that I could add on to that.
Yeah.
I can give you up to 10.
Have 'em.
You need to stop talking so I can finish what I need to do, okay?
I'm telling you, I'm not guilty. That's what I'm telling you. I did not have a choice. I have doctor, I have went to the hospital and everything.
I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition because of the judgment entered
I
against.
don't have a gun.
I'm not, just listen to what I'm saying. If you'll listen for a minute, you'll understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition.
I don't have a gun, ma'am.
Good, then you don't.
I'm the wrong person. I'm Devin Atkins. I don't have a gun.
I'm required to read that to
I
everyone.
don't know what you're talking about. I don't have a gun.
Good.